Welcome to the Financial Planning for Canadian Business Owners podcast. You will hear about industry insights with award-winning financial planner and entrepreneur Jason Pereira. Through the interviews with different experts with their stories and advice, you will learn how you can navigate the challenges of being an entrepreneur, plan for success, and make the most of your business and life. And now, your host, Jason Pereira.
Hello, Rachel.
Hi, how are you?
Very well. Thank you for taking the time today.
My pleasure. My pleasure.
So, Rachel Blumenfeld of Aird Berlis, tell us about what it is you do.
So I am an estates and trust group at Aird Berlis. Our group is part of a bigger tax group, which has about 29, maybe even 30 at this point, lawyers in the tax group. And our smaller area, we do estate planning, a lot of working with trusts, so will planning, will drafting, powers of attorney, and as well, at the end of the day, estate administration. So get involved in all of those aspects. And in terms of on the tax side, I get involved where we're doing what we call estate freezes for families, for business owners. I usually do the trusts that get set up at the time of those kinds of transactions and work closely with the tax people who on those.
So we're going to circle back to some of those topics, but basically I brought you on to kind of do a 101 on what business owners need to know about estate planning. So simple synopsis, I always say estate planning is all about making sure that what you have goes where you want it to with as little pain and taxation as possible. Hopefully you're going to have some of that, but hopefully you can minimize it. But let's talk about what's involved in that process. So basically, what's typically the impetus for the conversation getting started in your experience?
So I find people come to us or come back to us when there's been a change in their life circumstance. A lot of times people will come if a parent or other close family member has passed away and they're now thinking about doing their own planning. This time with the pandemic has been extremely busy. And I know across the board in Toronto and other colleagues, we're all pretty busy. I think people are starting to get concerned, whether it's about doing wills, doing estate planning. Maybe there's been a change in the value of some of their assets and they want to take advantage of that. And also people are worried about things around care. We've heard a lot about what has been happening in the care homes and get people coming in and saying, I definitely don't want this or I want that. And you want to make sure that that's drafted properly. So we're spending, I think, more time on powers of attorney than we used to.
Yeah, there's nothing like a global crisis or world event that reminds you of mortality to make you do the estate plan. I remember the number of people after 9/11 who basically started getting their wills updated. It was substantial. So let's talk about the documents involved in putting one of these together. So an estate plan is really not just about, I don't want to make people think that it's about documents. Like that is the product. The planning around that is so much more important. But let's talk about the check boxes of the product. We'll get into some planning concepts in that.
So usually, and it's a process. So even though you may end up with a couple of documents at the end of the day, or a lot of documents at the end of the day, they're documents that have to get revisited and revised and reviewed every couple of years. So typically you'll have, especially if the impetus is concern about a will or whatever, we'll prepare wills, we'll prepare powers of attorney for clients. In Ontario, we worry about not just the federal income tax that occurs on death, but also the probate fees or probate taxes. It's called the estate administration tax that can arise. And it's a small percentage compared to, capital gains tax or compared to a tax on your RIF or your RSP. But it's a tax that can actually be managed fairly easily. So usually, rather than just ending up with one will, you'll end up with two wills. One that deals with the assets that would require probate for an executor to be able to deal with them. For example, investment accounts that are owned directly, real estate that's owned directly. But anything that's in a corporate private company, that generally can be dealt with without probate. So an executor can have the directors transfer those assets without having to probate the will. So what we do is we carve those assets out and we deal with them in a separate will that ends up not getting probated. So you're saving 1.5% of the value of an estate on those assets.
And just some background there. I mean, my understanding is that if there's a list of assets that have to be probated according to law, and if a single asset on a will has to be probated, the entire will has to be probated. So that's why we have
all the assets.
Exactly. So we can group them into probatable versus non-probatable, and it's nothing on the first 50,000 in Ontario now, and 1.5 thereafter. And 1.5 is not a big number. But if we start getting into like businesses of multiple millions of dollars, I'll use a big round number of 10 million, now we're starting to talk about $150,000, which the cost of a secondary will is, take a couple zeros off of that.
Yeah.
People, business owners often said to me, like, why do I need two wills? I said, well, this is one of the highest ROIs as a financial advisor.
I like that. I haven't thought of it that way, but
there you go. Well, I mean, like,
and it's actually more than just the cost of probating. I mean, there's the fee that you're paying to the government. There's the cost that you're paying to the lawyers or whoever's preparing the documents, and there's also the time factor, because it's taking. I know there are changes coming down from the provincial government to try to speed up the probate process, but it's always a couple of months. So if you've got assets that you need to access, you want to have them in that corporate vehicle because you can do that. So it could be even a property that's held in a corporation as a bare trust. So
we're gonna come back to bare trust.
Yeah, well, I know that's something we've talked about before.
Let's do some more fundamental stuff here. Okay,
it's also a timing thing, not just the cost.
Absolutely.
Of the fees.
And the work, right? I mean, if you don't have to go through probate, you don't have to go through all of that. So that makes perfect sense. Yeah. So let's talk about what has to be probated and what doesn't have to be probated.
Okay. So it really depends on the transfer agent. So what I mean by that is the bank, the financial institution, or the land registry office. What do they require in order to deal with the executor? So what the probated will does is it gives that transfer agent comfort that they're dealing with the right person or people or entity, that even if down the road another will comes to light that has a different executor, if they've been dealing with the executor that's named in it's called a certificate of appointment, they're covered. So it gives the banks and the other financial institutions comfort with that. So it's not necessarily that there's a legal requirement. It's a lot of times it's a risk requirement with the institution. With real estate, I think it's more of a legal requirement that you can't transfer most real estate in Ontario without a probated will. There's a couple of exceptions, but
and it makes sense. A will is just a pile of documents with some signatures at the end of it, right? Without some sort of government appointment authorization to say, we recognize this is valid, right? Those institutions bear the risk, right? So this is like risk mitigation of them. Yeah. So those are cases that have a transfer agent. Like, so what would typically fall outside of what something that needs to be probated?
So if under a will, a person is leaving all of their personal effects, their jewelry, their artwork, to their kids. The kids aren't going to need probate in order to get those transferred to them. So those kinds of assets. And the big one and the main one that and the one that really drives a lot of this process are shares of private companies. So it's especially where it's a family business, it's closely held. Not a lot of shareholders. You'll have the directors, and the directors may end up being the executors. They're comfortable that they're dealing with the right people. They're comfortable that the will is what it is, and they will then transfer the shares to the estate without having to probate the will. You can get into issues with that, and we've had that where we've done planning, and there were two wills, and the corporate assets were dealt with in what we call the secondary will. And then the husband dies in the middle of a sale to a third party. And that gets a little bit tricky. So it doesn't, I always tell people this is how it works. You could end up with it not working properly, but it generally goes very smoothly.
Well, that's generally kind of a rule, right? Like we set these things up and hopefully they work. And if anyone tries to challenge them, they will hold up. But at the end of the day, life happens, right? And things can go sideways and laws change and people get unhappy about their lot. There's lots of issues there. So
the other thing that I always remind people is this works today in Ontario. there are other provinces that have high probate fees, same based on value, and it doesn't work. And they deal with, the way they deal with things is different.
Yep. And it's not just that. I mean, every now and then the rules change on us, whether that be through legislation or through some unfortunate court rulings, which almost threw out every will in the country recently.
Yes.
Yeah,
yes, we did have that a few 2 years ago.
Sometimes the court rulings don't go right. Anyway, so you touched upon something called the Bear Trust. So I'm going to give you the leading question here. So, this specifically has to do with when people own property. So let's call it recreational property, a cottage. Tell us, or investment property, what is a Bear Trust and how can it help?
So a Bear Trust is like a nominee. It's essentially a company that goes on title just to hold as the legal title holder of that piece of property. The beneficial owner, the underlying real, in quotes, is still the person that owned it initially. So if I decide I'm going to do this with my house, my husband is the legal and beneficial owner right now. We transfer it into 12345 Ontario Inc. That's what goes on title, but he remains the beneficial owner. And the way we demonstrate that is there's a declaration of trust, or sometimes it's an agreement, a nominee agreement that sort of stands behind the title that indicates that this person is still the beneficial owner. So when we set this up, there's no land transfer tax. If it's a principal residence, it continues to be a principal residence. And then what happens is it's registered on title in the name of that company. When the person dies, as long as they have 2 wills, what the executor is dealing with is the underlying beneficial ownership, and that can get transferred without having to have a probated will.
Yeah. So again, just like we did before with the secondary will for the business, same basic principle here. And it's interesting that the entire concept of beneficial versus title versus legal ownership will really play with people's heads, right? Like, and people sometimes don't get that. This is one of the issues that is core to disputes over joint accounts, right? Oftentimes we'll see people move accounts jointly to avoid probate. And frankly, sometimes that begs the question of, wait a sec, what was the intention here, right? Did they mean to give you this entire thing where they're just trying to avoid probate? And no, you do have to share it with your siblings, right? So, there's lots.
There were a number of cases, I don't know, a decade or so ago now that went to the Supreme Court dealing with that. We had a ruling, but it still happens. It goes on. There's monthly, every month, cases dealing with joint accounts that get messed up. Or joint assets. Yeah.
It's funny. There was someone posted this kind of warning story on LinkedIn, and my exact comment was, "This is why all joint accounts should come with legal disclaimers warning you of this risk." Right? Like the number of times joint accounts have been a major issue in estate litigation is just there's probably entire libraries full of these things.
Exactly. Yeah.
Yeah.
Yeah. And so, what are you saving? You're saving 1.5%. So that 1.5% is easy to save, but it also can create huge issues.
And this is the thing, is the number of times I see people going through all these obstacles and jumping through these hoops over the concept of like, well, you just see the probate. And then you point out like, wait a sec, you're trying to save the probate on like $100,000. Like you do realize that this is like 50,000 is free first of all. So now you're talking about 1.5%. They're like, oh, is that all? And it's like, they were going to go through all this stuff, all these hoops that was going to create complexity in the estate plan to avoid that. And it's just, there are sometimes, I will say this much, people don't always agree with me. It's a good thing to be probated sometimes, right? Like,
well, yeah. I mean, there are actually a couple of reasons you want probate. First is if there are other issues around, if you're the executor, you may want that piece of paper saying, yes, I'm the executor. There are certain limitation periods that only start to run once the probate has been issued. So the main one being dependent support claims against an estate. So yeah, there are reasons you might want probate. We go to a lot of trouble to try to get out of it, but yeah, it does.
Yeah. Sometimes just to throw your hands up in the air and say, you know what, 1.5% is worth it if it means that there's going to be a document that is fully that is not going to be disputed, more or less, because we know it's the accurate document. It's stamped, and my kids understand the wishes, and therefore that's the end of it. So it's a little bit of assurance as opposed to some of the other tactics we see out there, unfortunately. Yeah. So I'm going to throw a monkey wrench at all this and say, okay, what needs to happen? Like, let's just say that this person, one of these people, is a American citizen. How does that change things?
Oh, yeah. So hopefully when you do the planning, you become aware, like it's actually every lawyer that does estate planning now on their forms or whatever, their intake forms will have a question. Are you a US citizen? Are you a citizen of any other country? And then specifically, are you a US citizen? Are you a green card holder? And the reason for that is depending on who are we talking about? Are we talking about the executor? Are we talking about trustees?
Well, actually, let's talk about all of it. Let's talk about the deceased person. How does this impact the deceased person? Then we can get onto executors and beneficiaries.
So if the deceased was a U.S. citizen, that means they should have been filing U.S. tax returns their whole lives since they were adults. A lot of times you'll find, especially somebody who's a U.S. person or U.S. citizen because their parents were, they may not have been filing. So then the executor really has an obligation to deal with that and, do they go through a process of bringing that up to date or whatever? Depends who you ask, but that's, I think, the first thing you have to think about. The other thing, and assuming then that they are filing in the US and all up to date, the other issue becomes, are they subject to the US estate tax, which for a number of years, we haven't worried that much about because of the huge, very high exemption that is available, about 11.5%.
When's the election? 11.5 million.
Sorry, 11 million, 11.5 million.
When's the election? As of this recording, in 8 days. Okay.
Yeah. So that may change, and that may change drastically in the next couple of years. So I know that when we talk to clients who are U.S. citizens, and when we talk to U.S. lawyers who are doing this kind of planning, people are making the assumption that that exemption level is going to go way down, go back down to whether it's 5 million or when I first started, it was like 600,000.
Yeah.
So you do have to be concerned about that. Now, the fact that the person is a resident of Canada is actually makes it a lot easier than if you were a resident of almost any other country and a U.S. citizen. And that's because of the Canada-U.S. treaty. And there's certain aspects of our treaty that help reduce that liability. So you can use foreign tax credits for the U.S. tax against the Canadian tax or vice versa. You can have essentially the way the exemption works is it's prorated. So if you're worldwide estate is around the level of what the exemption is, likely you wouldn't have estate tax. You still have to file a return, but there'll be these back and forth foreign tax credits. And so I guess the last thing I was saying really is more affects not the U.S. citizens, but the testator, the deceased person who owned real estate or assets in the U.S. They have that exemption.
Exactly.
So you do have to look at all of those issues.
And then where's the complication with if they're an executor, if you name an American citizen as an executor, specifically, let's just say they're actually, make it the worst case scenario, they're in the U.S.
In the U.S. So the first issue is if you need to probate that will, in Ontario, the executor is required to post a bond if they're living somewhere other than Canada or a Commonwealth country. So that's a bit of a hassle. Usually the courts will waive the bond, but it's another sort of step in the probate process. So that's sort of your first hurdle. It's not terrible. You can get past it. There's the convenience. There's somebody in the US, the estate's here. I actually just had something where, there's two situations with US citizen resident executors. In one case, she was the only child. She lives in the US and she has to do it. So for her during this period, she's had to come to Canada, around when her dad passed away. She was in quarantine for 2 weeks, and then then she was able to start to deal with things. And now she has to, in order to ensure that the estate remains a Canadian estate, she has to come back for the closing and that kind of stuff. The other situation can be with banking, where there's certain types of assets that the deceased person owned. You can get into an issue whether the banks will deal with you if you have a US address. So there's those kinds of complications. On the US side, you'll have, my understanding is you may have reporting in the US because you're now got control over a non-US account. So you
Yeah.
have
So
FBAR reportings in the US.
yeah, and they may deem it to be a trust that's taxable in the U.S. As opposed to Canada because you're in control of it. And even so much as, believe it or not, if that person becomes deceased before the estate is distributed, it could actually be technically included on their estate return as well. So it is a hornet's nest of issues besides the convenience.
But, on the other hand, I've had situations where there really is nobody else. The kids all live in the US. The kids are inheriting everything, then. So it's sort of you have to really weigh the situation each time.
Yeah. In those cases, I think it's, where they're basically, the kids are going to inherit everything and they're all in the States. I mean, fair play. I mean, that makes a lot of sense. There's no real negative there. Whereas the issue is when you have some trustee or executor who's in the US and the beneficiaries are in Canada, there can be negative implications in those instances.
Yeah, there can be tax issues and cross-border investment issues, that kind of thing. Yeah.
And aggravation. Let's just be honest, all aggravation.
Yeah.
Yep.
And not being able to get across the border.
During COVID. Yeah, it's a big issue. It's nuts. So one of the things you touched upon briefly, and we touched upon it previously on the show before, but I want to go back over it, is the concept of an estate freeze. So let's go over what that is and how it benefits business owners.
So essentially what a freeze does is you figure out what the value, determine what the value of a business is at a particular time. The business owner, the founder, and this, I'm sort of just giving you the standard example that we often see. The founder says, that's enough for me. That $100 million business that keeps on growing, that's enough. I'll keep my $100,000 and the future growth can go to my kids. And what you're doing.
100 million, but yes, and it must be nice, but continue.
100 million.
Yeah, exactly.
Yeah, my numbers are off a bit today. So 100 million and my kids can get the future growth. But what I'm doing with that is I'm fixing my tax liability on death. So I'm saying I am, whatever the tax is going to be on that growth up until now, that'll get paid at on my death, but that's it. I'm sort of stopping that from running.
Or freezing
it. Exactly. So what you end up with is the parents, for example, end up owning the current value. The kids, or more likely a trust for the kids, holds the future growth. And you've pushed out that tax bill on that future growth to the next generation. So we've actually been doing quite a lot of that kind of work now, because to some extent the values may be a bit lower because of COVID. And so this may be a good time to get a valuation, to do the freeze, to sort of, fix that tax on death. I've
had a couple of conversations where people are just not getting the counterintuitiveness of this. They're like, well, I should be doing this when I'm doing well. I'm like, no, you should be doing this when you're not doing well, because if the goal is to minimize or to fix the tax liability on your death, and you're leaving shares to giving shares to your children, like the reality is that we're just, if you recover post-COVID and you're doing really well, that's just money that's taxed in their name, not yours. And it's all legit.
Yeah. I mean, there's I think you raise an interesting point. Why, what that counterintuitiveness is that, well, you still want to make sure there's going to be enough there for you and your kids aren't entitled to way more than you are, perhaps.
There's a threshold of wealth, right? Yeah. There's a threshold of wealth. You're not going to do this when I've, the capital gains exemption, for instance, right? It's sitting at 868,000 roughly, something right now. So, I mean, the temptation is always to say, okay, well, I can freeze it around here. Well, maybe that makes sense, but it depends, right? If we're talking about passing on to the next generation versus maybe to a spouse, passing on to the spouse, not a big deal. But the next generation, it's like, well, that's growth you're never going to have. And is the 868,000 in tax-free enough money to plan out your retirement, for instance, right? The answer is going to be no in most cases, right? So yeah, it's all relative. So it makes sense when it makes sense.
And there are tax, you have to be careful when you do them. There are tax issues that have to be dealt with. You have to look at who your beneficiaries are. Is there a U.S. citizen in the mix? Is it, did one of the kids marry an American and now there's a half a dozen American grandchildren? And then those situations, you really have to ensure that there's U.S. advice.
That is putting it lightly. It's amazing how much U.S. tax code screws everybody else in the world.
Yeah.
Good. So, I mean, we've covered some decent ground. We've talked about how, the need for dual wills, at least in some jurisdictions like Ontario. We've talked about how probate works. We talked about estate freezes and the implications of U.S. citizens and bare trust. That's a fair amount of ground to cover. Yeah. Is there any kind of like general advice that you feel you want to give like to business owners when looking at this kind of planning?
Sure. Yeah. I think there's a couple of things when you're starting to do the planning that you want to keep in mind. One big one is who the executors should be. Who are the people or institutions or entities that are able to step into your shoes, deal with, especially if you're dealing with a corporate, family business, can step in and really ensure that it continues smoothly or is able to sell the business. And, so you really need to look at family dynamics. And whether there's, that you're dealing with a second family, a blended family, second marriages, third marriages, whatever it is, those issues have to really be addressed. And you have to be straight with your advisors. If you know that one of your kids has an addiction problem, you got to tell me. I don't know that, you come into my office, I don't know everything. I try, I think any estate lawyer is going to try to probe and get information, but there's, sometimes there's some hesitancy, but you really have to be prepared to really open up and talk about those kinds of issues. Because we then see when it doesn't work out, when things have been missed, and I have to go down the hall and get my estate litigation partners involved because it's not going to go smoothly.
Yeah, it's interesting. We actually have a full disclosure policy that we actually put into our letters of engagement with clients. We tell them before we bring them on, like, look, we're going to ask a lot of personal stuff and we need to know. And we're not that trust me, I do not enjoy hearing about the negative things in people's lives, but I can't help you fix them without it. And it's really, I actually just had this conversation today with someone who reached out to me. I had sent them to another advisor because there were prospects to another advisor because they weren't quite a fit for what I did. They needed a really specialized need. They came back saying, well, they're asking me for all this personal info. And I said, well, yes, because I would do the exact same thing. Here's 5 examples of how, like, without knowing everything, it can go wrong. So yeah, it's funny because we're often told to protect our personal information and not disclose stuff. But when it comes to your advisors, you really got to open up. Otherwise, they can't help you. Yeah. And if you think estate planning is expensive, try doing it 2 or 3 times because you didn't disclose it properly.
Right. Yeah. Or, I mean, I know you'll be dead, but try dealing with the litigation afterward. And
there's no worse way to destroy your dynamic, the family dynamics after you're gone than to leave a messy estate behind. Because I've literally had people say to me, clearly my parent did not give a damn about us because they couldn't be bothered to prevent us from blowing up afterwards by simply putting a document together. It's terrible. But you know what, though? I will say the counterpoint to that is everyone, once they're done, they feel a lot better about it being done, don't they?
Yeah, that's true.
Excellent.
That is true.
Well, Rachel, thank you very much for this. I very much appreciate it. We covered a fair amount of ground and complex ground pretty quickly. But where can people find you if they want to reach out?
So I am at Aird Berlis on the internet, Rachel Blumenfeld. Yeah.
We'll be sure to include a link in the show notes.
Okay.
Excellent.
Great.
Perfect. Thank you so much for your time.
Thank you.
This podcast was brought to you by Woodgate Financial, an award-winning financial planning firm catering to high net worth individuals, business owners, and their families. To learn more, go to woodgate.com. You can subscribe to this podcast on Apple Podcast, Stitcher, Google Play, and Spotify, or find more episodes at jasonpereira.ca. You can even ask Siri, Alexa, or Google Home to subscribe for you.